everyone. Hello, everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. This week, we're talking about surrogacy, and in particular, how it fits into the picture when people separate or divorce. Now, surrogacy in itself comes with layers of emotion. There's a lot of logistics, legal complexity. But when you have separation on top of that, the challenges can feel really overwhelming. So in this episode, we're going to try and unpack what makes divorce in those cases so uniquely complicated and the key points that parents need to understand to avoid potential issues. To talk about this, I've invited Natalie Sutherland. Natalie is a specialist family law solicitor and partner at International Family Law Group in London. She spearheads the firm's Modern Family Department, where she deals with surrogacy, assisted reproduction law, including donor conception and platonic co-parenting, as well as advising clients on the whole spectrum of family law issues. Natalie, it's great to have you here today. Thank you for joining us.
Thank you for inviting me.
So I guess the first question that comes to mind when we think of surrogacy and how that fits into the picture when you're getting divorced is really who's recognized as the legal parent at birth and then potentially later on when there is a surrogacy arrangement under English law.
Yeah, so our UK law considers the birth mother as the legal parent. Now, that is wherever in the world the surrogacy takes place. So even if you are a British intended parent and you commission a surrogate in the US, for example, because your child has been born via surrogacy, even though you will have a US birth certificate potentially with your the intended parent's names on it, our law in the UK wouldn't recognise that. So you have to go through a parental order process in order to remove the legal parenthood of the surrogate and any husband or spouse, wife, because our law would consider them the legal parents at birth. But you go then through a post-birth court process in the UK to remove their legal parentage forever and confer it on the intended parents as it should always have been, as envisaged by all parties. So, so you go through that parental order application at court. You end up with a court order that says that you are the legal parents, and then the birth is re-registered and the intended parents are named on a British birth certificate as parent and parent.
So just to clarify, if you don't do that, you're not legally the parents of this child. Is that right?
No. So if your surrogate is single, then the biological father would be considered the legal parent, but he wouldn't necessarily have parental responsibility. And if you're in a heterosexual couple, then the intended mother has no legal status at all. So so I suppose in the context of a divorce and separation, it's important to go through that process to ensure that the right parents are the legal parents, so that so when that order is made and you have that birth certificate, it doesn't matter if one of you is biologically related and one of you isn't. If you then subsequently separate, you are going to be treated if you can't decide on the child's arrangements, you would then have to use the court under the Children Act to ask the court to make orders in respect of your children, and you will be treated as any other parent because you are legal parents with parental responsibility, and the court isn't going to go behind that parental order to say, well, or to favour, for example, the biological parent as opposed to the non-biological parent. So it's particularly important to go through that parental order process to sort out the legal status, but it is actually not a requirement. So you could go through a surrogacy and have a foreign birth certificate and never go through a surrogacy parental order process because it's not a requirement. So there could be people out there who have undergone surrogacy, who have a birth certificate with their names on it in a foreign jurisdiction.
That's misleading.
Everything's okay, exactly. So there was a case a couple of years ago where a married couple discovered through their own surrogate in the US going through a second journey, whose intended parents were also British, who then asked her to consent to this parental order. But she had not been asked by her first set of intended British parents many years ago to do that. Now, this child was over 18, not living with the parents anymore, but it was very important that they sort out the legal relationship, because what a parental order does is it transforms the legal parentage forever. So this is for the rest of that child's life. So you have that legal connection to your child forever. So this child is now 18, but actually in UK law, in this case, was never the legal child of this couple. And they actually never had parental responsibility for him.
Crazy.
And they didn't know. They just didn't know. So what they did was they took legal advice and then applied for their parental order. And of course it was given. So that was fine, but what Mrs. Justice Tice calls these cases is like a legal ticking time bomb. So had that couple separated, or one of them died perhaps, and then they discovered that they hadn't got legal parentage for their child and had to fix it. Well, what if the person who died, or the separated couple, what happens then? Can you apply together? Or if the person that's died is the biological connection? So because you have to satisfy so many Section 54 criteria, over the course of time, you may fall out of satisfying those criteria. So that's the reason why it's really important that anyone who has a child through surrogacy obviously takes legal advice at the outset of their journey to make sure that they are eligible for the parental order. Then they have their child in whatever jurisdiction, but then come back and take more legal advice and then apply for the parental order, so that they have that legal parentage, so that it protects both of them if there should be a separation later down the line.
Yeah. So there's that final step, I guess, that some people don't realize is required. But if their surrogate is in the UK, does that happen automatically, the parental order, or do you still need to apply for it?
No, you still need to apply for it. Now, the Law Commission they have put forward a draft bill with law reform proposals, where if you are in a UK journey and you satisfy a number of preconception checks and you go through this new regulated pathway, that the intended parents could then be a legal parent at birth and wouldn't then need to apply for the parental order. And there's a period of time where the surrogate can change her mind, and then you may have to go, or the surrogate may have to make an application if she were to change her mind. But that is not law at the moment. So there's no suggestion from the government yet that they are even going to look at it. They say they don't have time. So we are stuck with the current law, and it's we just have to use the law as we have, and any particular case that maybe falls out of one of the criteria, we just try. So for example, there's a time limit, so it's a 6 month limit that is still on the books, so you still have to make your application within 6 months of the baby being born. But if anyone's listening to this podcast now that goes, oh, I've had a child through surrogacy, I didn't know this, it's now too late, you should still make that application. So in this case I'm telling you about, they obviously had to deal with that time limit issue, but cases previous to this have dealt with it. So when I say dealt with it, I mean the court has basically said it's in the child's best interest for the application to be made, notwithstanding that it's outside of the 6 month time limit, and that Parliament could not have intended for there to be this cliff face where you can apply and you can't apply. So those types of criteria we can deal with. But things like a surrogate's consent, for example, you can't get around. So with this case that I was telling you about with the over 18, they obviously were able to get their surrogate's consent. What if you can't find your surrogate, or the surrogate?
18 years later, they could be anywhere.
Exactly. I mean, the Act does allow you to not have to have the surrogate's consent if they cannot be found, or if they're incapable of giving their consent, but you still have to do all you can to try and find them. So
it's an extra hurdle to overcome.
Exactly.
So what happens if parents have omitted this step and haven't got the parental order? What is the risk for the parent who hasn't have formalized legal parentage if they come to divorce?
Yeah, so it's then you're dealing with two parents, one who may have the biological connection, who kind of feels a little bit superior. And it's usually in a sort of heterosexual couple, for example, it's usually the male who has used their gametes. So the man will be biologically related, and maybe there's an egg donor. So the woman in this situation probably feels even more vulnerable because they don't have that biological connection and they don't have the legal parentage. Whereas the man could still be a legal parent if your surrogate was single. But what the court shouldn't be doing, and it doesn't, is favour one over the other if there's a biological link. We don't have that biological trump card. But what you would then need to do, really, is sort out the legal parentage first. So, and again, deal with, well, do we now satisfy all of those Section 54 criteria to be able to get the parental order, and then deal with, well, how will you sort out the children's arrangements now you have separated, assuming that you can get that parental order. If you can't, then the court's going to have to deal with it on a different basis.
And so how would they deal with child arrangements orders if one of the two isn't a legal parent? Can they still obtain that kind of order?
Well, in this situation, the child would likely have been living with its parents, and if there's a reason, so for example, they can't get the parental order for whatever reason, but it would still be in the child's best interest for there to be orders. So ultimately, you are going to get the court that's going to look at, well, what is in this child's best interest, so that you're not going to get a court that says, well, you don't have the parental order, so you now can't see your child, for example.
Well, yes, that's the risk. Exactly. Yeah.
So the court will do everything it can to try and sort out the situation. So make sure everyone's got the PR that they need, and make sure then that you have maybe a lives with order or spends time with order. So, but that's not the optimum situation. The optimum situation is legal parentage with PR, with your birth certificate, with your names on it, and then you're in the same position as anyone else, and then you go to court if you can't agree your child arrangements.
Yeah, of course, that's when that's the simplest. So what can they do preventively? If you're a couple who is about to embark on the surrogacy journey, what steps can you take to avoid these kind of issues later on? Because 42% of marriages end in divorce, so it is something to plan for.
Absolutely. And if you are a heterosexual couple, you're likely coming to surrogacy from a traumatic fertility journey. So it's not often plan A for a heterosexual couple, whereas it would be for a same-sex couple. Yes. So if you're in your heterosexual couple and you're coming to it from fertility, your relationship could be under strain anyway because of everything that you've experienced. And surrogacy is a long road involving lots of moving parts, lots of different people, and it can be extremely stressful. So I would say have the best team that you can around you, and take all the advice that you can. So if you're going abroad, you are going to need immigration advice. Pick your agency well, do your research, research the clinics. So, because there are so many different people involved, professionals now.
Yes, I imagine.
That it is really important to be able to trust and trust those people, so that you know that everyone's got your best interests at heart, and then steel yourself for a potentially long journey, and then take counselling if that's going to be helpful. Support each other, and but ultimately you take that legal advice and you follow it, and you go through the legal steps. So while some people, when they come to me, they might have spent a lot of money before they come, because
it's IVF and that kind of thing.
Exactly. But the legal side is not where you scrimp, with you cut corners. I mean that genuinely, not to try and drum up business, but because it has a profound impact on the child. So and sometimes if you haven't maybe taken the legal advice at the outset, and then you discover that you need to take legal advice now because something's happened, it's probably going to be more expensive to deal with the fixing.
Yeah, to fix a problem.
Rather than taking that advice and then knowing the parameters of the decisions that you can make, and then making those right decisions for your family.
Especially if you fought so hard to have this child, just do it properly and make sure that you've got all everything in place so that your rights are protected and the child's welfare will be protected as well. Exactly. So I think when we were preparing for this podcast, you mentioned an interesting case, which I think hopefully doesn't happen too often, but it can very much happen, is when the breakup happens during the pregnancy. So the child isn't born yet. And how do you deal with that in the courts? And how do you recognize people's responsibility and roles if the child isn't there yet?
Well, is that or if you separate after the baby's been born but before the order is made? So at this point, so the separation, So what we discussed before, just now, was that get your parental order and then if you've split up later down the line. But if you have separated during the process, then absolutely you each should be taking your own separate legal advice. But then we need to consider, well, can you still make that application together, even though you're no longer a couple? But what the court knows is that you are in an enduring family relationship. And there's been cases that have dealt with the home requirement, okay? So the Act says that the child must have its home with, if there's two applicants, both of them, at the time the application is made and at the time that the order is made. So there's 2 points in time, okay?
Okay.
So you could hit one. So we were in the same home at the time the application was made, but you could be 8 months later until you get the order. Splitting up in that time, and now the child lives in two different homes. Or you could have split up before you make the application, but you're still making it together, but the child's living in two separate homes, so you don't fit both of those criteria.
Yeah.
But what the court has done, and again, it's trying to bend over backwards to try and make sure that this child's welfare is protected, and has said that a child's home, it's with its parents, even if it's in two separate properties. So it looks at the term home purposely. Yes. Whenever you say that word. Make sure that you can fit all the other criteria. So ultimately, this child is going to be brought up by its two parents, but they may not be together. They may be in separate homes, but the case law has allowed that to happen. So there are ways of dealing with it. And whenever I see my clients at the outset, I will sort of go through the Section 54 criteria and sort of know the ones I can tick right now. But there are ones that I can't tick right now, which is the home at the outset, and when you make the application and when you make the order is made. So I make them aware of there being these 2 points in time, but also that other cases have come before theirs. So we can deal with it, but it just means that it's a slightly more complex application.
Yeah. So if the couple were to divorce or separate during the pregnancy, then you would recommend they wait for the child to be born, then get the parental order, and then deal with any kind of child arrangements. Would that be the sequence?
Yeah, you can't get a parental order before the child's born anyway.
Okay.
So even if they divorce during the process, I would assume that they would. I assume that they would be together when the baby was conceived, but if they divorce in the meantime, again, we would be talking about, well, how do you make that application together? And then if one doesn't want to then pursue.
Yes, that was what I was thinking. Yeah.
How do you then deal with that? Because there's been cases that have dealt with that as well. But what you need is, because when you're in a couple, some aspects that you only need one to be. So, for example, the biological connection. Yeah. So you can have both being biologically related or just one. So, for example, what would you do if you've split up and you, as the intended mother, have used an egg donor, and your husband, you've split up now, and he doesn't want to pursue matters, and then you've got to go as a solo applicant, but you can't fit that biological criteria. So what do you do then? Well, we're probably looking at adoption at that point. So because you wouldn't fit that biological connection criteria. If it was the other way around, if you did, then and you could still fit all the rest of the criteria, you could proceed as a single applicant.
So one of the applicants, at the minimum, needs to be biologically related to the child. Is that it? Okay.
Yes. We don't have double donation, so you have to have. So if you're a single applicant, you have to have used your gametes. Now that probably disproportionately impacts women, actually, because if you are a woman who needs surrogacy because you can't carry, you're potentially unlikely to be able to use your egg as well. Which means, so it means that you would need to. You wouldn't be able to use surrogacy, but I do actually have single women as clients who go to jurisdictions where you are allowed double donation. Then they have a birth certificate with their name on it, and then and then come back here. But of course, they don't have legal parentage, so they have to adopt. But that's also, slightly more complex actually, because there are other criteria that you need to satisfy. So yeah. It's
then you're going through two processes, the surrogacy and the adoption, and both of them are quite heavy. Yeah, that's definitely even more complicated. So if people have done things properly and they've got their parental order and everything's in place, but life happens and they split up, how do the courts in England and Wales treat child arrangements in those cases? Do they just look at it like any other situation, or are there particular sensitivities and nuances that they take into account?
So I think it will be dealt with as any other case. But if you, so I've been dealing with other cases where, so for example, the surrogate changes her mind, and therefore you can't now get a parental order. Have her consent. The court can't override her lack of consent. So now you're dealing with matters under the Children Act, and whilst the best interest of the child is obviously the most important factor, you probably are going to want to know about the nuances of how this child came to be, because there is a surrogacy involved. Whereas if you have a surrogacy and you've got your parental order and everything is fine, but later down the line you split up, but you can't agree on child arrangements, and therefore you have to go to court, I can't imagine that the court is going to, favour one over the other because of because one's biologically related. It just won't take that into account. So it will just be what's in this child's best interest, and that's the same as every other case.
So that must be a real source of reassurance for people who have done the paperwork properly. It doesn't matter, really.
It doesn't matter. No, exactly. Yeah.
That's really helpful. So I guess I'd like to finish the podcast with kind of your top 3 tips for people who are going through surrogacy and like anybody else are susceptible to separating at some point. What would you recommend they do and try and prevent happening?
So first is get the advice. So understand the parameters in which you're working, and understand there are things that you don't know. So do your research, see who it is that you gel with in terms of your legal advice, and take that advice so that you have considered all of the options, and absolutely take that advice at the outset of your journey. The lawyer that you instruct should hopefully have lots of connections worldwide, so they'll probably be able to help you as well, build your team, or at least sort of guide you. There are some, I don't know, some people that we probably wouldn't want our clients to go to, some jurisdictions we wouldn't want our clients to go to. So take that advice from an independent lawyer, and build your team. So make sure that you have all of those professionals that you feel comfortable with, that you trust. And what else? I think just be resilient. So there is a long journey, and there can be huge bumps in the road. We use the word journey in the analogy all the time, because that's what it is. It's a long journey from that first decision to go down the surrogacy route to having a baby in your arms, and then having that final court hearing where you get the parental order. That could be 2 years of your life. It's a long time. So and life happens in between. So I think just you have to be prepared for the unexpected, but do all you can to mitigate that by getting the best advice you can.
Yeah, it comes back to your first tip, really, around getting the right people informed. And it's just like in divorce, having the right team around you is going to make such a difference, because there's so many big decisions being made. Exactly. And you're emotional. You're emotional when you're going through a divorce, but you're also emotional when you're creating your family. So especially when you're having to use third-party reproduction, you're having to use lots of other people, professionals, clinics, lawyers, agencies. It's overwhelming. So take it step by step. But yeah, do your research and take your time. Thank you for those words of wisdom, Natalie, and thank you so much for joining me today.
You're very welcome. It's been lovely. Thank you.
Have a good day.
Bye.